All right. Well, good afternoon, or actually, good morning, everyone. I'm rushing the day here. Thank you all for attending this incredible series of Building a Business Best Practices by Ryan Reister. I am Linda Knowlton, your immediate past president, and we thank you for attending this for the first session. And there'll be other sessions of coming in the next couple months. If you have any questions during the course of this presentation, feel free to type them in the chat box, and Courtney and I will monitor them and shout them out to Ryan as we go through this. So it is my honor to introduce Ryan Reister, who is again Reister Law, and Ryan has been at the forefront of representing mortgage companies of all sizes for over a decade. Ryan founded Reister Law in 2008 in order to utilize his years of experience in the mortgage industry to assist mortgage companies and trade associations. Since the beginning of his legal career in the mortgage industry, he has gained a deep industry understanding, which keeps his clients informed, compliant with regulations, and conducting businesses. In addition to the extensive mortgage industry experience, Ryan works with a variety of businesses, including trade associations, nonprofits, startups, and political action committees. In his tenure as outsourced general counsel for multiple entities, Ryan keeps clients informed of current legislative and regulatory issues in their industries, preparing them for impending law changes. He is highly regarded for his skills in public policy legislation relations and government affairs. No matter the issue, Ryan and his team always deliver superior advice and creative solutions to help their clients thrive. Ryan's been part of FAMP for a number of years here, and we value him very, very much. And the only thing you left out of here, Ryan, is that has a beautiful wife, Megan, and 4 little kids so, that are your partners in crime as well. So maybe I shouldn't say crime. But anyway, I will turn it over to you, Ryan, and take it away. Thank you so much.
Thanks, Linda. You definitely embarrassed me reading all of those, good things that, some of which might even be true. But hopefully you will make it through this webinar. But you might see two of the little ones that Linda mentioned. They are running around here and quite fond of all Zoom meetings. They like to, Zoom bomb whenever possible. So, bear with me if that happens. Thanks for joining today. Really happy to be able to present on this topic. It's one that is, it's really near and dear to my heart because the biggest thing that I enjoy about what I do is helping people and helping people achieve success in what it is that they want to do. And when it comes to building a business and starting your own business, it's something that I have a passion for, as I'm a business owner myself, and I like to do what I can to help inspire and also guide and inform others who are looking to do the same thing. So let's see, let's start. There we go. Just a little brief overview of what we're going to cover today. And I'll give an initial disclaimer. So we probably have a mixed audience here. Some of you might be thinking about going out on your own and starting your own business. Some of you may already be business owners. Today, in this first part of the webinar series that we're doing, it's really going to be focused more on those of you who are thinking about going independent and going out on your own. This is going to be a expansion of the conversation and the type of conversations that I have when prospective clients reach out to me, both inside the industry and outside the industry, and their interest in starting a business. And so we're going to talk about, first and foremost, is starting a business really right for you? There are a number of considerations, and it isn't for everyone. I have colleagues who sometimes want to smack me in the head, and they're just like, why would you have that conversation with a client or prospective client? You could be turning business away. I said, that's okay, because if it's not right for them, I don't want to set them up to fail. I just want to set everyone up to succeed. So I always start with that kind of initial conversation where we say, all right, let's explore your motivations, your drive, your interest in starting your own company. We'll talk about what's involved in starting your own broker business, your own mortgage company, the costs to be prepared for, the timelines that you want to be aware of, as well as existing obligations that you may have that will factor into not necessarily your ultimate decision to pull the trigger and go independent, but how you want to approach that and strategize that. We'll look at different business entity choices, and talk through some of the considerations you want to weigh when choosing the right entity for your business, the right entity type. We'll talk about drafting your organizing and your governing documents. Those are going to be very important and something that you want to um, give adequate time and attention to up front. It's not something that can never change and will never change through the life of your business, but it's something that you want to give the thought to when you're organizing so that you're starting off on the right foot. And we'll close by talking about some ways that you can prepare for your transition, and hopefully that'll put a bow on some of these other subjects that we're going to cover in a little more detail. I can't say anything more about myself that Linda didn't, nor do you want to hear any more about me, I'm sure. This is the slide my wife always gives me grief about, including she's like, why do you have to lawyer it all up? Everything else looks really good, but it's still important to just, set ground rules. If you're asking questions, try to keep it to generic information only. Don't share any non-public information about yourself or your company. Being here today is not creating any type of attorney-client relationship between us, and so there's no confidentiality. Obviously, there's a number of you on the call, so anything that you do say or type into the chat is public information. Nothing that I'm providing you today constitutes legal advice. This is information only. And it's always important that you do seek out, particular legal advice. We'll talk in more detail about that as we go through the slides today, but this is hopefully gives you a starting point and helps you ask the right questions of your individual legal advisor. Also, I'll just say I have a lot of industry experience in working with mortgage brokers and lenders and others in the industry. I'm not myself a licensee, so I know there are nuances to holding a license and obtaining a license that some of you who are holding licenses already know, but that is not something we'll go deep into here. So getting started, as I said, I always like to say, what is your why? What is your reason? What is your motivation? What's driving you particularly to want to start your own business? And it can be any of these, all of these, a combination, or something completely different. Some of the more frequent explanations that I hear from folks are, I want to have more free time. I want to be able to control my schedule a little bit more. I don't want to have to go into the office. I want to be able to work from the beach or from vacation. I want to make more money. I don't feel like I'm getting paid. My current boss is only paying me, 75 bips a transaction. I know I can do more. I want more control. I want to be the decision maker. I want to decide which lenders we're working with, which investors we're working with. I want to decide, who to hire and how to position the business. All great reasons to start a business. It's important when you're thinking through this question yourself, or whether you're talking through it with, maybe a family member, a potential business partner, or with an advisor, whether it be a CPA or attorney, that you approach these questions with some honesty, internal honesty, and then some objectivity, because this is where I try to lend some experience as a business owner myself. All of those things are possible when you own a business, and they're fantastic when they come to fruition. They don't happen overnight. It's not a switch that you can flick and automatically and immediately you have more time, more freedom, more money, more control. You do have more control, but I'll exchange the word control for responsibility, which sometimes becomes then a suck on your time, your energy, your freedom, and ultimately your money. I don't say that to discourage you. It's just, for me, it's all about setting realistic expectations with anybody who is approaching entrepreneurship or starting their own business. Setting expectations. Oftentimes, expectation is one thing, and reality is quite something else when you get into it. So, in terms of setting expectations, some of the things we're going to dive into here next are going to be your timelines, thinking through how long it realistically takes to open up your own business and go from concept to operational. We're going to talk about the costs involved, because it does not have to be a cost prohibitive exercise, but even in the most efficient ways possible of putting together your own business, there are hard costs involved that can't be avoided, especially in this industry. And so because of the licensing involved, So we're going to talk through costs and make sure your cost expectations, both timeline and costs. I will tell you from experience of numerous conversations with folks that are in positions you guys are in now, thinking about your businesses. This is often overlooked. A lot of times the expectation is, clear skies and smooth seas, and I can give my notice to my employer and be operational and running very quickly. That the reality is somewhat different, and it's important to plan for that. Existing obligations that you have currently and going forward are something else that we're going to talk about, because these are another set of important considerations when looking to, go out on your own. So setting your expectations in terms of timeline. Number of things to consider here. One big one that I believe everyone I've ever talked to always is thinking about and considering, it's your current pipeline. If you are a active loan originator already employed by someone else, you have a pipeline, you have clients that you're trying to serve and that you want to make sure you take good care of. So you want to be thoughtful about what your pipeline looks like today, what it looks like going forward, and think through a realistic schedule for, do you typically have some downtime in your year? Do you foresee market forces indicating that there's going to be a little bit of a downtime? These things can weigh into when you decide to pull the trigger and whether you decide to pull the trigger. I've seen that happen as well too, where business gets so good, market conditions are so good that it's delayed somebody's decision, someone who was very committed to going independent, and the market just was too hot to let go of the pipeline that person had at the time. The calendar, the actual calendar, this matters more than I think people sometimes give credit to. Not just in terms of the flow of business and in buying and selling season on the real estate side of things, but in terms of licensing. The NMLS calendar really affects the timeline for getting new licenses approved. If you're trying to become licensed roughly now, this time of year, as we're about to start Q2 or into Q3, almost every regulator is going to be able to process your license application a lot more efficiently. Is going to be able to give you a lot more hands-on attention and answer your questions if you have them, as compared to if you're trying to become newly licensed during renewal season. The regulators that I've worked with all across the country are really good, and they try to manage both the renewals and the new applications, but they have limited resources. This is true in every state, including in Florida. And so they do the best they can, but they have obligations to make sure the renewals get processed on time. And so sometimes it takes longer than at other times during the year to get a new license approved. You also want to consider the work that's involved in starting your business. I have to, and I always try to work with prospective clients and clients on outlining a timeline for that is realistic in terms of what needs to be done. We're going to talk through a number of things today relative to the documents you need to put in place, the things you need to think through in terms of licensing, your licensing applications and everything. All of those take time, not just on the processing end, but on the on your plate. It takes time as well to compile the documentation necessary to launch your business. And so this is usually something that can't be done effectively in a matter of days or even weeks. We're usually talking about a month or months to get everything in order for a variety of reasons that I'll touch on, as we go through the day. But the work involved, it is again, not such a heavy lift that it should deter any of you from launching your own business, but it's something you want to go into with your eyes open. And I have third parties as another timeline expectation that you want to consider, because it is entirely possible and perfectly fine to launch your own business 100% on your own without the assistance of any third party. A lot of people do that every day, and people do it effectively every day and have launched hugely successful businesses without, financial advice, legal advice, consulting advice, any of those type of things. But if you are engaging with third parties to help on those things, that's something else that can affect the timeline, because again, most of those third parties are working with numerous clients, and they're not necessarily going to be in a position to, turn something around or turn a volume of work around for you in a really short amount of time. The second, kind of expectation setting category I identify as costs. I think it's important to approach the start of your business with realistic cost expectations. There are hard costs that can't be avoided in terms of actually forming your entity and filing the paperwork with the Secretary of State, as well as licensing in our industry. And so those are hard costs that you need to be prepared for. They're not particularly prohibitively high costs, but we're still talking in the neighborhood of $125 to organize your business and $600 roughly for a broker license in the state of Florida, $300 for your individual MLO license if you're just starting out and you don't have your MLO license yet in Florida. And so these are things that you want to plan and prepare for. It's not a zero cost proposition. Office space, however you'd like to define office space, there's going to almost certainly be costs involved there, even if you're deciding to operate out of a home office environment when it comes to setting up hardware, software, technology, security, internet security, digital security, things that are necessary for our business. So not something to be overlooked, the costs involved there. Insurance, that's another cost that's going to, again, it's a hard cost that I guess technically could be avoided, but it'd be wildly irresponsible to start your business off that way, and it's something I'd highly discourage. And then the bottom two are much more optional, but things that you want to think about in terms of getting your business off on the right foot. Any branding. So you're launching a new business, even if you have a strong pipeline, you have a strong set of referral partners, you're confident that business is going to flow to you. Creating that new name recognition, that new brand recognition for your new company is going to be important. And you might be a brilliant marketer, graphic designer on the side. There might be any number of reasons why you can DIY that effectively, but you may need to invest some resources in getting your name and your brand and your logo and your marketing collateral put together. And then legal. Again, there's absolutely no requirement for any business owner starting out to seek legal advice. It's highly advisable, and I always say that to encourage everyone to take that with a grain of salt, coming from an attorney who works with clients on starting businesses. It is extremely valuable to get good advice, not just in the legal space, but on the financial side of things and the insurance side of things. So toward the end of the presentation, we'll talk about assembling the right team around you and how important that can be. But you want to manage your expectations of costs as well, because anytime you're engaging third parties, there are going to be costs. And as any of you guys know from every other aspect of life, there's a huge range of cost and service levels that are out there. You'll almost certainly be able to find someone that meets your budgets, your budget sensitivities and comfort levels, but also is extremely competent to help you. And so finally, when I'm talking about setting expectations with clients, it's examining the existing obligations you have and how that might affect your timeline, how that might affect your approach as to when and if you really are ready to go out and start your company. So again, back to pipeline. Every mortgage originator that I know and that I've worked with in my career really strive to put their customers first. I'm sure that's not an absolute universal truth of every LO, but I've had the privilege of working with very good ones, in my opinion, and they always talk about wanting to take care of their customers and making sure that their customers and their clients aren't left in the lurch, so to speak, if the LO is transitioning from one company to another or starting their own business, where there will likely be a lag in the time when they can service those clients. So you want to think through your pipeline in terms of serving your clients. And then I already touched earlier on your pipeline in terms of your cash flow. What does it look like there? Cash flow, that dovetails nicely into the second item here. There will almost certainly be a lag between the point where you say, I want to go out on my own and my business is operational and I'm actually earning commission again. What that lag looks like is going to be different for different people. Different based on the time of year that you maybe apply for your license and can get it processed, and different in terms of how organized you are up front. So you want to think do I have the reserves, personally, to withstand a month or 2 months or 3 months or more without any commission checks flowing in while my license is pending, while I'm getting my business up and running, before I'm able to actually close loans in the name of my new company. And then finally, and I will say most importantly, and very often most overlooked, is any contract that you have with your current employer. All of you, if you're currently employed by another mortgage company, have to have some type of a compensation agreement. The vast majority of mortgage companies fold that into an employment contract. When I say employment contract, I use that term somewhat loosely because we're pretty much everybody's an at-will employee. It doesn't mean that you're guaranteed that you're going to have stay employed, but the contract dictates the terms of the relationship between you and your current employer. This is something that can and does really limit loan officers' ability to go independent, and really can affect the timeline and extend the timeline oftentimes. So I want to dive a little deeper into this particular point because I think this is valuable if you are considering going out on your own. And it's important first for you to understand what to look for in your own contract before you even necessarily reach out for legal help if you feel the need to. But there are several key terms, provisions, sections in your employment contract, most likely. I will kind of put out the caveat that the devil is always in the details in any contract document. So each person's is going to be slightly different. Each person's contract is going to be maybe slightly or significantly more or less enforceable. So there is value if you have any concern about your obligations to your current employer in engaging legal counsel to look at this and to advise you of the risks involved, the limitations that you have moving forward. So everyone thinks, okay, what do I have to worry about a non-compete? Non-compete agreements, non-compete provisions in your contract are widely debated, all in every industry, particularly in our industry. They are in most LO employment contracts to some degree, and they are enforceable in the state of Florida. They are not enforceable everywhere, and they're not universally enforceable. They have to be drafted properly. They have to be narrowly tailored to protect a legitimate business interest of the employer, and they generally speaking can't be overly burdensome on the employee. They can't impact an employee's ability to earn a living, for example. They can't be overreaching in terms of the geography, the scope, the time, among other things. So if you have a contract that has non-compete language in it, that is, and it may not say non-compete, it may take other forms, and I'll reference kind of the nuance between non-compete, non-solicit, and this confidentiality provisions. But in general, a non-compete provision is telling you in one way, shape, or form that you are prohibited from going to work with a competitor of your current employer. That, as I said, can be enforced if it's drafted narrowly and carefully. Will it be by your employer when you leave? That is very subjective and impossible to predict upfront. The circumstances of each employee's departure really dictates that quite a bit. But you need to be aware of it. You need to think through what impact that can have if you are being restricted in any way, shape, or form from going to work for a competitor, because starting your own business would be deemed a competitor. Some of you may have seen and heard there is a lot of talk on the regulatory side of things that the federal government is considering a ban, a prohibition on non-compete agreements. What that's ultimately going to look like, no one's sure. Again, no one's also sure the enforceability of something like that, even from a federal agency like the Federal Trade Commission. And so that's something we're monitoring relative to the enforcement of non-compete agreements. But regardless of how that comes out, and I'll say this as kind of not a warning, but just a heads up that if you do read anything that the government has banned non-competes, they're illegal, they're unenforceable, whatever. Don't assume that that creates, again, smooth seas for you to just go do whatever you want. And that's because of some of these other two provisions I've highlighted here. Um, Many LO employment agreements have non-competes. Virtually everyone I've ever seen has non-solicitation provisions and confidentiality and trade secret provisions. Those two types of contract clauses are much easier to enforce and are able to be drawn much more broadly. They still can't be so broad that they make no sense. But these are provisions that you do need to look for in your contract and be aware of. Non-solicitation comes into play in two regards. First and foremost, your current employer is almost certainly going to prohibit you from soliciting your coworkers to leave with you and go work for your new company. Whether you're starting your own company or going to work for another entity, there's going to almost certainly be a non-solicitation provision for a period of time. Usually it's a year, sometimes it's longer, where you cannot actively recruit any employee of your current employer to leave and come work with you. If you do that, these are provisions that do get litigated. This more so than the non-compete, because it's a little bit more enforceable, and because, to be quite frank, it really pisses employers off when entire teams of employees leave at the same time. They tend to be more aggressive in pursuing these non-solicitations. The other prong of a non-solicitation agreement that's in, again, almost every loan officer agreement that I've ever seen is going to be employer for a period of time. This one is much trickier. It's much more nuanced in terms of the way they're written, in terms of their ultimate enforceability, and in terms of how these work in real life. Folks like me can sit behind a computer screen, draft what we think is a brilliant, concise, narrowly tailored non-solicitation provision. But then if my client comes to me and says, well, I need to enforce this, we have to have a very frank conversation about the realities of business and of our industry in terms of, where did the leads come from? Did the company provide all these leads and contacts to the LO, or is the LO out there developing the relationships himself or herself? Did the LO bring these leads to your company and now you're trying to take them as your own? There's lots of different things that happen in reality in our business that can affect the non-solicitation. But again, non-solicitation provisions are litigated over, not just with employees, but if an employer believes, or a former employer believes, you are pursuing their customers or their clients, or who they perceive to be their customers or clients. Related to the non-solicitation, and usually kind of as a additional hook, similar to the non-solicitation of customers and clients, are confidentiality and trade secret provisions. These are often gigantic paragraphs in your employment contract. Sometimes I have seen multiple pages just dealing with confidentiality. I don't find those particularly fruitful, because I call those kitchen sink confidentiality clauses. If you're claiming everything is confidential, then nothing's really confidential. That's kind of weak, but it doesn't mean a court won't enforce it still. So you need to be aware of what is in your confidentiality clause, what your current or former employer defines as trade secrets. This is often, the fight here is often over contact information of customers and clients. So as LOs, you guys all maintain your customer client databases, but the company does as well. And the fight is, who does this belong to? If a company has, your current or former employer has a strong, well-drafted non-solicitation and or confidentiality trade secrets provision in your contract, you could find yourself in potential litigation with that company if you leave and then try to reach out to your contact list. Again, I'm not saying this to discourage you from starting your own business. I'm not saying this to discourage you from reaching out to your contacts list that you have built and cultivated over your career and your time in the industry. It's just something that is important to be aware of. because these are where fights begin whenever you're switching employers or starting your own company. And I would say another piece to consider, which is, I mean, it's not really becoming super prevalent yet, but I'm starting to hear about it a little bit more and more. And that is relative to referral sources. Who quote owns the referral source? Is it the company or is it the LO? Again, just like the client, company wants to fight over it and really wants to expend its resources to protect its position that it owns, quote unquote, the clients or the referral sources, then this is an area where you may need to seek legal advice and brace for potential litigation. So I've said several times, I'm not saying any of this to discourage you from thinking about going out on your own or going out on your own. It's just making sure your eyes are open to what can happen. I have a significant number of people that do call me after they've gone on their own, and because they've gotten a cease and desist letter, or they've had a complaint filed with the court against them for violating one of these provisions. And then we really have to dig in and check on the enforceability of it. And you're talking at that point, as soon as you've responding to a cease and desist letter is going to, you're going to spend thousands of dollars on legal counsel to do that. If you're drug into court, you're going to spend $5,000 to $10,000 just to get it out, even if you win. And so that's why be proactive about this. Read your contracts, understand the terms, ask questions. Talking to a competent employment attorney, a competent attorney in the mortgage space ahead of time is going to be a lot more cost effective for you. So you know what you're getting into, and that attorney can help you prepare to make the transition in the most seamless way possible, and in the way that's least likely to cause escalation of something legally. So that was a lot of talking by me, a lot of downloading of somewhat meaty information. I'll pause for a second here, mostly to get a drink of water, but also if anybody has any questions, Linda, Courtney, in the chat, or if anyone wants to ask a question up to this point, I'm happy to entertain that.
I do not see any in the chat, but would welcome anyone that has a question to maybe shout it out now before we move forward. You know, I'm always kind of perplexed with, as you said, the non-compete and the non-solicit, because that is very, very hard to do. When you said referrals, I know that is, I see that in the real estate world where teams have left, people have left teams and they've taken the referrals or their client base. And there's been, you know, some lawsuits pending on that. So it's always interesting and perplexing, because who really owns who, right? As far as.
Yep, most definitely. And I hate to throw that term around, but I mean, we always say who owns the client, who owns the referral. You know, nobody can own a client. The client's free to do what the client wants to do, but these contracts govern your actions and how you approach that with the client and what your level of contact with that client is. And again, I'll say the best drafted provisions that are fair and on both sides and enforceable, generally speaking, accommodate the realities of client choice and the realities of working with your pipeline, working with, you know, your referral sources. But the vast majority of contracts that I've seen with companies are not fair, are not balanced, and are not, you know, often not particularly enforceable. And but that's not something you can bank on, is the unenforceability, because like I said, it's going to cost you money. A fundamental flaw in our legal system.
So if someone's planning to leave and start their own brokerage and they have a contract, it's important for you or someone to review that first.
Yeah, absolutely. It's most important for the individual to review it themselves and read it and see what they think it says, and if they have any questions, seek legal advice, again, from somebody an employment attorney is great, but sometimes there's nuance in specific industries. And so generally speaking, an attorney who works in the mortgage space is going to be very well versed in how these are drafted, which ones tend to be enforced and enforceable, and that's, so either way, an employment attorney or someone who's practicing in the mortgage law space would be who I would consult. And again, it's not going, that will generally not be cost prohibitive, engaging on the front end. Once you've already run afoul of it, fixing that with legal counsel is always more costly.
Yes. We just had one comment that there's not any questions, but one of our attendees is excited to be here as they have started a new brokerage of a year now. So this is good information for them. So.
Well, I appreciate that. I'm excited that you guys are here. I hope I'm not putting everybody to sleep. So I'm glad to break up the sound of my voice with Linda's. She's got a much better tone. So.
Well, that's okay. We do have someone, Tanya has a question. Do you want to shout it out, Tanya? You want to type it in the chat box, whatever you prefer.
I can shout it out. I have a question.
Sure.
So if we haven't had this yet because we're a new brokerage and we have had some people leave, but say in our CRM, because we do it through UWM is who we're partnered with. And so we have our CRM is called Blink. Hold on. I'm sorry. My dog just got in the room. Yeah. I apologize for that. So we use Blink. And when we have a separation and that LO leaves us, their contacts kind of stay in the Blink, like they're not, unless they've deleted them, they're there. I want to make sure I understand, on this solicitation thing. And I haven't seen, I would need to look at how our paperwork, our onboarding paperwork and contract reads on this, because I really don't know what he's got in there. But if I'm understanding what you're saying, we need to be really careful how those people are marketed to from us, because it could be perceived that we're taking that LO's pipeline, that they're not with us anymore, right? Because I believe I've heard my husband say he's the broker owner, and I believe I've heard him say before, well, they left them behind, they're free game. But they're, from what I'm hearing, they're not really.
Yeah, it's a great question. Thank you for asking this, because I think this will, this is a good line of conversation for us to have. So if someone is leaving your company and their contacts are all in your CRM system, generally speaking, an LO who leaves you is, I would call it very rare. I've never personally seen where an LO has gone back to their former employer and accused the employer of improperly retaining that information. And particularly in the situation you described, it's your system. It's your CRM system that information is in. And so there is I'm going to say default, but there is a strong presumption that is your information because it's housed in your system. Now, the reality often is, from my experience, what I see is that LO may have left that information in your system and probably always will, but most likely downloaded it all to their own private file at some point in time before they left. Very rarely have I ever seen LOs leave without taking that information or keeping a separate log of information for all their client contacts. That's where you as the employer may have an issue with them. If they downloaded that out of your system, that could be in violation of your employee handbook, your employment contract with that LO. And so that's where you as a company owner, might have a cause of action against an employee.
I probably
or LO
wouldn't, but yeah.
So that's a whole nother piece of this puzzle, is whether it's worth pursuing enforcement. Generally speaking, even as a business owner, you don't want to waste the time and money trying to enforce it to prove a point, unless there's some significant harm that this LO is likely to cause or is causing your business.
Because they don't have access to anybody else's files, just their own. So I'm like, you want to, the system actually doesn't let you download, like you can't import to an Excel, but that doesn't mean if they weren't, you couldn't sit there and copy and paste it one by one. I mean, it's not hard to do. They probably already had a record of it anyway as they submitted it. I would, right?
Most definitely. And that's where you probably say the devil's in the details a number of times today, but that is true. Like, I've seen that litigated over where downloading the information out of the employer's CRM system is violated, has violated in terms of the contract. But if an LO maintains his or her own separate
Right.
database of information, it's a lot harder for the company to say they own that, because the LO did the work to put it together, arguably came upon that information independently. That's usually what's fought over. But no, like I said, great question, and that's just a perfect glimpse into what in my experience really happens when someone leaves.
I
That was a
gotcha.
great question.
Good. Thank you for
Tanya.
that clarification.
I do have another one, Ryan's, for a small broker owner with 3 to 5 LOs, wouldn't it be pretty rare for a court to enforce a non-compete against a departing LO, and this depriving the individual from earning a living? Better for the broker just to move on without litigation? That's question.
So I'll answer that in two parts. It is, and it's another area where colleagues sometimes smack me in the back of the head when I say this, but it is almost always better to avoid litigation. Almost always. There are extremely rare instances where litigating is your only option, is the only way forward. But very, very rarely is that the best solution for anybody. And so that's kind of part one. It's for small businesses in particular. Generally speaking, the only people that benefit from litigation are the litigation attorneys. They're going to get paid no matter what, whether you win or lose. And sometimes you lose for winning because of the amount that you're paying in legal fees. In terms of whether any effort to enforce it by a small business makes any sense, that's going to be a business decision that everyone has to evaluate for themselves. You want to weigh, and some of the things in general that I talk with clients about thinking through are, if you don't seek to enforce these provisions, do you risk a mass exodus of your employees because they feel like you didn't go after so and so, so I'm free to go do whatever I want. If one of your highest producers is leaving, does that really, and they take their pipeline with them, and you don't try to stop them. What does that do to your bottom line? What does that do to your business going forward in the short term, midterm, long term? So these are, again, fact dependent considerations that each company, each business is going to have to look at. You referenced in the question enforceability. It's going to be really hard for a court to enforce any provision that will prevent someone from earning a living, from performing work in their chosen field. So in our space, you're a licensed LO, you leave your company, and there's a non-compete that says you can't go work for anybody who's compete anywhere in the state of Florida that's a competitor of us. Well, a court's going to look at that and say, okay, how is this person supposed to make a living, assuming the person lives in the state of Florida? That's where they're the only state they're licensed in. Yeah, there are other factors that can weigh in, but generally speaking, that's going to be overly burdensome to say that person can't go earn a living for 3 months, 6 months, 12 months. So that would likely be unenforceable. And when I work with clients, I talk to the business owners, the companies, about not weaponizing your contract language, not using this non-compete provisions as scare tactics to be like, you're never gonna be able to work for anybody if you ever leave me. I don't find those productive. I try to discourage that because I know they're very unlikely to be enforced. But again, strategic provisions that are enforceable and can protect your legitimate business interests, like not letting them or restricting how or for how long they have to wait before they solicit clients of your firm, those do matter, and those can have an impact. Restricting them from soliciting your employees can matter, so that, if you're a small broker shop, like you mentioned, 3 to 5 LOs, if 3 of them left, that would put a real hurt on the business. And so, that non-solicitation does matter. It doesn't mean they're not all going to leave voluntarily. But again, putting thought into how you craft these provisions around, and the key term is your legitimate business interests. Not everyone gives enough weight to the legitimate part of a business interest, because it's in everybody's business interest to keep all your clients, to keep all your employees that are good ones. But you know, if you take a fair and balanced approach and you be realistic about it, I think there is a sweet spot there. I've seen it, and I've worked with clients on creating it.
Okay. All right, great. That is the end of our questions for now. If you want to.
Perfect. Thanks.
Again, if
Don't
any
hesitate to
questions.
fire them in the, yeah, go ahead.
Yeah, no, I was just going to say, as we move forward, type in any questions and we will get.
Linda will be glad to interrupt me, so and give you guys
Yeah,
a
I have
break.
no problem doing that. You're used to that, actually.
Yeah, absolutely. So this is a good transition to our next kind of larger section of conversation, and that's around entity selection. So we've gone through the evaluation of, do we want to start our own business? Do we understand, do we have realistic expectations over what it's going to take? Yes. And so now we're prepared to start getting organized and start thinking about what it actually is going to look like. There are far greater than the 3 entity options that I have on screen here. These are by far the most popular to consider and to choose from. And if you have specific questions about other entities, like a limited partnership or a general partnership or a limited liability partnership, there are quite a few different entities you can select. But for the most part, the vast majority of companies do and properly fit into one of these buckets. And so that's what we're going to focus on for our purposes today. The sole proprietor, a corporation, or a limited liability company. When we're thinking about and thinking through the entity selection process, it's again, this is another area that's often overlooked to a degree by folks who are starting their own business in every industry. People tend to have in their head one of 2 things. Usually it's either a corporation or an LLC, and it's just because, you know, that's just what I thought I needed to do, or that's what, you know, my neighbor down the street did, or, you know, there's a lot of, you know, reasons why people just jump to one or the other, or they decide they don't want to incorporate, they just want to be a sole proprietor, and that's usually motivated by, you know, cost considerations, simplicity, ease. But again, that's something that needs to be well thought out, because there are a number of facets to this decision that you want to think through, and you can see some of them identified here. Your tax treatment, your asset protection, which is the limitation on liability, the flexibility that the different selections provide, privacy. That's something that is not often thought about, but choosing the right type of entity for your business can afford you certain privacy protections in terms of, you know, what of your own personal information, including even your name, is put out there. Credibility. This is something I see a lot out there. I don't put a ton of stock into that. I think you may get some boost in credibility by having that Inc. or corporation or LTD or LLC after your business name. I think this gets overplayed, but it's something that's worth thinking about, because there are people out there who are still more likely to work with an incorporated or organized business than with someone who's operating as a sole proprietor under a DBA. It's something to just kind of be aware of. I wouldn't put a ton of weight on that. And then also growth, you know, making sure you're choosing the right entity to position your company for the growth that you envision and desire over the life of your business. So starting with sole proprietorship, I'm not going to spend a ton of time here because, as you can probably glean from the slide, I highly discourage anyone that I work with from operating as a sole proprietor. It makes very little sense to me if you are seeking to open and operate a business for the long haul. It's better to just go ahead and create the structure up front and create it, you know, the way you want it, and know that you're gonna be in it for a while. The sole proprietorships, I see people do this when they think they're kind of testing the waters, dabbling into, well, do I really want to do this or not? That's a fair reason to consider it. I think you're sticking your neck out unnecessarily. Also, I think sometimes just arrogance kicks in here, and I'll use a very close example, a personal example here. I didn't organize my firm as an entity when I first started out. Looking back with the perspective I have of representing businesses and clients for the past 15 years, I was an idiot. It made absolutely no sense. But at the time, I was, you know, opening up my firm out of my home, and I wasn't renting office space. I wasn't having people over, clients over to my home or my office. And I said, what, any bad advice I give, I'm responsible for anyway. And so, what's the point? Well, we're going to get into what the point is in the next couple slides, but it's it's something that from experience I discourage, and thankfully I never had anything unfortunate happen. But I think I would have been further along in a number of ways had I just put the time and energy and thought into organizing properly from the beginning. And so that's the advice I give to all my clients now. We'll talk about incorporation next. There's a lot of overlap in terms between forming a corporation and forming a little bit limited liability company relative to the benefits. Some of the disadvantages are where the nuance and different lies. Incorporation is preferable to, or forming an entity separate and apart from yourself is, whether it's a corporation or a limited liability company, is preferable to being a sole proprietor, primarily because of that first bullet up there. It's limited liability. Another phrase you might hear used and thrown around even by me is asset protection. So incorporating allows you to protect and segregate your business assets from your personal assets. And it may not seem like much when you're starting out. It didn't for me. But as your business grows and thrives, and as you potentially take on employees, potentially open up a storefront to welcome clients in, potentially are traveling to visit clients, and there's a lot of things can happen that are bad and unforeseen or unforeseeable. Exposing your personal assets to business liabilities is it's almost irresponsible. And so that's why I heavily encourage people to form an entity. So a corporation does create that limited liability asset protection for you. Corporation also offers you flexible tax treatment. You'll hear me talk a little bit more detail probably later on in the presentation about putting the right team around you, getting the right advisors engaged to help you and make sure you're thinking through things properly. And one of those folks is a CPA or an accountant. It's not a member of the team that a lot of my clients come to me with, but it's somebody I always talk to them about identifying whether they know someone or need somebody to be referred to them. But how you set up your business from a tax treatment standpoint can vary, even within a corporation, even if you're a corporation. And so you want to make sure it's the most advantageous for you personally and for your business. Common misnomer, and so something I always like to highlight here is people hear about C corporations and S corporations. Those are strictly tax elections. They're not two different entity types. You cannot file paperwork with the state of Florida Secretary of State and say, I want to be an S corporation. You just file articles of incorporation and you are a corporation. The C and S are subchapters of the tax code that dictate how your corporation will be taxed. The C corporation, as most people bristle about the C corporation, is the fact that it's subject to double taxation. So the corporate entity is going to pay tax on its revenue, and then the distribution of profit to you, the owner, or the owners, the shareholders, is going to then be taxed on your personal tax return. If you elect the subchapter S tax treatment, it's passed through taxation that will not get hit at the business level, but will just pass through to the owners. So this is important that you talk to either a CPA, an accountant, or a tax attorney. This is not something that I endeavor to advise my clients on deeply in terms of the decision-making process. I try to educate and inform my clients to look into this and investigate it. I'm happy to answer questions when my clients have them, but I am a big believer in identifying experts. Let the experts do what they do best. And advising on tax matters is not what I do best. I know a little bit about it. I know probably enough to be very dangerous, but that means I know enough to keep my mouth shut to a certain point. But the reason I flag it here is you do have the flexibility to choose your tax treatment in a corporation. It is important to do that upfront and make sure it makes the most sense for you. One of the drawbacks to incorporation, and this is really the biggest reason for me why I personally advise the vast majority of my clients to opt for a limited liability company, it's that corporations are product of statute. They're entities that are created under the law, and LLC is as well. But what I mean by this is they're more rigid structurally. There are more formalities that you need to follow in a corporation. You have less flexibility, less fluidity in terms of how you manage, set up management, how you handle bringing on additional owners, how you handle profit distributions. You know, those things are all largely dictated by statute and precedent, and it's pretty, you're in a box when you're a corporation, and that's okay. There are other advantages to a corporation if you, depending on your aspirational goals for your business. Corporations sometimes are easier to spin off and sell if that's your ultimate goal. They're sometimes easier to acquire cash infusions in terms of investments because it is so straightforward, and investors are familiar with the corporate structure, and they don't have to do as much due diligence as they might with a LLC. That's a product of contract, a product of an agreement, and we'll get into the details there. But it's the biggest takeaway I'd have if you're thinking corporation or liability company is corporations, generally speaking, are a little bit more rigid, a little bit more formal, and kind of put you in a box. And so that's not to say don't incorporate. It's still better than going out as a sole proprietor. But I personally advocate for LLCs because I like the flexibility that they provide. And that moves us into the discussion about LLCs. And so here you see I interchanged, I don't even think I did it on purpose, but limited liability, asset protection, those are synonymous. They achieve the same thing on the limited liability company side as it does on the corporation side. It's a shield to or a wall, whatever your metaphor you prefer is, that divides your personal assets. So your house, your savings accounts, your retirement accounts, those type of things from your business assets. And so that way, if something were to happen within your business where you would have liability, the maximum exposure you would have would be those assets that are within the company, within the corporation or limited liability company. LLCs also have extremely flexible tax treatment options. You can choose on an LLC to be taxed as an S corporation, which is favorable for a number of people. You can choose to be taxed as a partnership if you have multiple owners, or it can be treated strictly as a self-employment situation where the terminology is a disregarded entity, where it's an LLC for liability purposes, but for tax purposes, you just file everything exclusively on your own personal tax return. Again, I can't overemphasize the importance of working with a really good CPA or tax attorney for that matter on what makes the most sense for you today and based on your plans, your goals for the business going forward. This is something that's going to be different too, slightly different depending on if you're a sole owner of a company versus if you have partners or co-owners. That's going to weigh in that decision-making process. And as I touched on the previous slide, I'm an advocate for the LLC structure because they are much more informal, much less rigid. There's a lot more fluidity and flexibility to how you structure things because it's, again, not based in law and in statute, it's based in contract. Your limited liability company, and we're going to talk about governing documents here, I think next, but your limited liability company is formed by filing your articles of organization, but your governing document is your operating agreement, and that is the compact, the promises that you make with your partners, or if it's just a sole owner situation, it's the roadmap for how I'm going to run my business. And so you have a lot of flexibility there. Some of you may have questions if you're in a multiple owner LLC structure already, or if you're thinking about it. This is usually where some complexity can come into place in terms of organizing. some delay in the timeline, as we talked about, can come in if you have multiple owners with potentially differing interests, differing views on how things should be structured, or and what's really often the case is owners are coming in with different levels of financial commitments and different levels of engagement in the business. And so the LLC is great because it allows for you to accommodate all that in an operating agreement, but you need to put the legwork in up front, ultimately with the help of competent legal counsel and competent a financial advisor, because these things, if they're not put together properly up front, tend to get way more complicated down the road once there's actual money involved. I see Linda popped up, so I think she's got something.
Yeah, when
for
you
us.
see my face, you know I have a question there. We
I
have
like
a
it.
question in the chat box, if you have a moment here. It said, I formed as an LLC for purposes of personal asset protection. Can you speak a bit about commingling of personal and business funds and the impact on piercing the corporate veil? Is it easy to use personal and business debit cards for purchasing depending upon bank balances, etc.?
Fantastic question. Thank you, whoever asked that question.
Yay.
I know, I just that is
Not me,
no,
Jeff.
that
So thank you,
that
Jeff.
that's an excellent question. I appreciate the question, and hopefully I can give you a thoughtful answer. You do want to be mindful of commingling funds. Commingling funds, as you alluded to in your question, can take a lot of different forms. As a general rule, commingling funds can expose you to loss of that asset protection, loss of the liability protection that you formed the LLC to achieve. It's not that black and white, though. It's not like I had to dip into my personal checking account to pay the electric bill for my office this month. That's not going to do it. It's going to typically be something that's more systemic, something that's more of a pattern and practice, and it's really going to be. I hate to say this, but and this is again where your financial advisor comes into play. It's a lot of it's bookkeeping. It's making sure that everything is booked appropriately and documented appropriately. As a whether you're a sole owner, well, let's take the example because it's easier. The sole owner of an LLC, if you need to infuse capital into the business, you're going to do it, and you're going to do it from your personal funds. To do it properly and to make sure that you're not potentially running the risk of commingling the funds, you want to make sure it's documented as a cash infusion, as a capital contribution that either doesn't have to be repaid right away or maybe even a loan. Usually a single owner LLC is just going to make the infusion of cash into the company and move on from there. Again, this is it's a bookkeeping challenge. If you've got the advisor out there that's helping you with the bookkeeping, he or she should be able to keep everything straight as between the contributions and any draws that you take out. But I don't know what I want to say. I don't want to scare you into, not paying your bills because, you have a cash flow crunch. That is not the case. The commingling issue comes into play when there's I will say a pattern and practice that makes it evident that the business is just a fiction, that the business isn't really a business. The business isn't operating as a business. You're not keeping any cash in the business. You're not trying to invest in the business. It's just a facade, a fallacy, like a legal fiction. That's when you're going to get the corporate veil pierced, potentially, is if there's enough of a pattern to say, yes, Ryan set up this LLC and it's there on paper, but in reality, he's paying bills out of his checking account and every cent that goes into the business comes straight back out. And he's not, not really maintaining business banking records adequately. Like those are the kind of things that will be scrutinized and will probably result in piercing the corporate veil. if it's a cash flow situation and you document it properly, you're not something you need to worry about. And I follow up, please, if I did not answer that sufficiently, please.
Okay. All right. We'll move on.
Awesome. So the next thing we've got here, we're going to talk about our organizing and governance documents. So we talked about entity selection, the thought process that goes into what type of entity do we want to form, and even do we want to form one? So I hope the answer after the last 10 or 15 minutes is yes, you want to form an entity, and ideally an LLC, but a corporation is fine too. Your organizing and governing documents. These are, generally speaking, the basic list to kind of check off. Articles of incorporation is the document you file with the Secretary of State if you're forming a corporation. Articles of organization are what you file to form an LLC. Both are extremely simple, straightforward processes in 2023, thankfully. There was a time when you would probably need or very much want legal help to create your articles of incorporation. Or your articles of organization. Right now, they're very simple, straightforward online forms. In Florida, you just go to sunbiz.org, I think it is, .com. But Sunbiz is the Secretary of State's website where you can access all the forms and filings that you need. And to technically form your business, once you drop those articles, then you have an entity that exists as soon as those are approved. And they're usually approved pretty instantaneously because there's not often a whole lot of detail that goes into those, because those are your organizing documents. The governing documents are really the meat that tell us how your business is going to operate and run. On the corporation side, those are bylaws. On the LLC side, that's called your operating agreement. These are not documents that are filed with the Secretary of State in Florida and are not typically filed in any state that I'm aware of. And so they're documents that are going to be internal corporate records, but still required. The state of Florida requires you to have corporate bylaws if you are a corporation. If you are an LLC, you need an operating agreement. It's not statutorily required, but you need an operating agreement to govern your relationship with your co-owners, your partners. And you really need one, even if you're a sole owner. I know that sounds a little silly. Why do I need to document my relationship with myself, my relationship with the company? It's not an exercise in futility. It goes actually back to the question we just tackled a minute ago. It is evidence that you are treating it like a business, that you have an actual business that exists separate and independent of yourself. It's not just a facade or a front or a legal fiction. It's real. And so crafting an operating agreement as a sole owner is worth your time and energy. If you talk to a competent attorney who approaches this, I think logically, it's going to be very short, straightforward, to the point, narrowly tailored to your business as a sole owner business. If you go online, you might be able to find that, or I discourage people from getting a voluminous operating agreement if they just own the business themselves, because again, that looks a little bit like you're not really operating this business. You're just kind of checking a box. So we'll talk in more detail about the importance of tailoring your documents to your specific business in part 2 of this webinar series next month, when we talk about policies and procedures and compliance management. But relative to your governance documents, that's important to hear too. It's important that you don't need, and you don't really have a 50-page operating agreement if you're the only owner of the business. I can't say with certainty that that's completely unnecessary, but I can't conceive of a situation where you'd have to cover that much information when you're the only owner. But again, you may if you have multiple owners. So the next thing you need to do, so you got your articles of incorporation formed, filed, and you have a business entity. You're working on your operating agreement, and we can talk a little bit more detail about that. I think on another slide here. Fictitious name filings, DBAs. This is a question I get a lot. If you're forming an entity, if you're forming a corporation or an LLC, I always encourage clients, organize under the name you want to do business under. creating a DBA or fictitious name for your corporation is fine. There's nothing wrong with it. It's generally speaking an unnecessary step. It then becomes an unnecessary administrative piece that you have to manage over the course of time, keep up on with renewal filings. And in many states, and I apologize, I have to do a little bit of a refresh on how Florida views this. In many states, the fictitious names are not as well protected as, you know, your actual corporate or LLC company name. And so, you know, there are circumstances where businesses change their direction, they change their branding, they take on partners, they merge. So there are reasons to sometimes get that. But when you're starting out and you're starting fresh from a relatively clean slate, I always encourage everyone to think about your business name, make sure it's one that you're happy with, because filing that as your actual LLC or corporate name provides the most protection, and it just makes the most logical sense. Related to that, I will just touch briefly on questions I get on in this area is, do I need to trademark my business name when I'm starting out? My answer is often no. You don't need to worry about that up front when you're starting your business, with few exceptions. I would say if you have an absolutely what you believe is brilliant, creative, unique name that when people see it, they're gonna fall in love with it and want to use it for their own. Okay, that might be something you want to protect. If you hire a graphic designer, or you are yourself a graphic designer, or have a family member who designs the most amazing logo ever, that might be worth protecting with trademark. If you have aspirations of expanding your business nationwide over the course of time, filing for federal trademark protection could be advantageous for you, because I've seen a lot of mortgage companies with very similar names in different states, sometimes exactly the same name in different states. And having some federal trademark protection can help protect your brand identity. It doesn't mean that you're not going to run into any issues with name duplication. But again, these are narrow circumstances where, for the most part, when you're starting a small business, you don't need to consume yourself with the time and energy and money involved in filing for trademark protection. It's something worth talking about with your advisor if it's on your mind, but not something I would spend a lot of stress or strain worrying about. On the financial side, when you're starting out, you need to register with the Florida Department of Revenue, and you need to get an EIN number from the IRS. The EIN application is super simple. It's available on the IRS website. They will give it to you instantly and then send you a paper copy in the mail. You're going to need that to open up a business bank account. And again, referring back to that whole keeping your separate business finances from personal finances, asset protection, you do want to make sure you open at least one business account in the name of the company. And so getting that EIN done, that is a very short, sweet, efficient process. Not something that you need to sweat over. So two other things, like I said, we're going to dive a little deeper into the operating agreement here next. Buy-sell agreements, succession planning is something else that is worth thinking about if you're going into business with partners or co-owners. I always advise clients to spend a little bit of extra time, a little bit of extra energy talking through the what ifs upfront. When you're starting out a business, everybody's friends, everybody's excited. It's going to be the greatest thing ever. You guys are going to go just shock the world and dominate the industry and be the greatest thing of all time. And that's the time to talk through what happens if, one of us meets an untimely end. What happens if we get bored and we want to go do something else? What happens if I win the lottery and I want to get out of this business and just go, live on a beach somewhere? All of those type of things. What happens if we want to bring in additional partners? What does that look like? Think about those up front before there's money involved in the business, because inevitably those are questions that are easier answered now when you're starting out than when you're trying to, deal with potentially raw emotions, with potential real dollars at stake. And so that's why I always advise, let's have conversations about buy-sell agreements and about, what happens over the course of time, projecting the success of the business long term. So, like I said, we're going to dive a little deeper into your corporate bylaws and your LLC operating agreement. I'm not going to spend a ton of time on your corporate bylaws because they're I take that back. I'm not going to separate these two and dive too deep because they're very similar documents. They both serve similar purposes in terms of identifying the structure for the management of your company, the ownership stakes, the ownership interests, and the rights that are associated with those, the decision-making power and authority, and so my point on the earlier side, any buy-sell provisions that you want to incorporate. You can do that with both types of entities and both sets of agreements. So I'm going to talk about the management structure a little bit. Under a corporate management structure, it's pretty straightforward. You're going to need to have a board of directors in place. That board of directors could be small or it could be large. It could be partners and owners in the company, or it could be outside advisors who you're relying on to help guide and direct the business. And we're going to talk toward the end here about putting a team together. Sometimes those on your team may be good fits for your corporate board of directors. Forming a board is not something to take lightly. Forming a board is not something to gloss over, because when you appoint someone as a director, you can always change that person out, but they're inherently going to have power to make decisions for the business. So you want to make sure that you have the right people involved in that decision-making process, and that they are they share your vision as an owner or as a majority owner in your company. On the LLC side of things, management structure can be a little bit more fluid. LLCs can be what's called member managed. So in an LLC, you're not called a shareholder, you're called a member, and you don't hold shares. Typically, you hold membership interests. So LLCs can be member managed or what they call manager managed, and that would be sometimes it's a distinction without a difference. Oftentimes, in the context of a sole owner, a solely owned LLC, it will be the owner who's de facto. I mean, that person is going to be de facto the manager. They often don't hire a separate independent manager to run the business, although it's possible. But when in your LLC operating agreement, you're outlining your management structure, the key here is differentiating what is a membership decision and what is a management decision. And so that's something that I always advise clients to think through. Membership decisions are those huge, the hugest issues and decisions that your business is going to face. Do we bring on a new partner? Do we change the name of the business? Do we, trying to think of some other things. Do we dissolve the business because it's just not working out? Do we merge with another business and sell the company? Those type of things are things that are examples of things you would very much want to reserve for the membership, because it directly affects your ownership value, interests, and rights. You also have management responsibilities and management power, and so the operating agreement is designed to speak to what specific managerial authority do the managers have. So again, in a single member LLC, not really that, well, it's not gonna say it's not relevant, but a single member LLC, it's a lot more streamlined, a lot more efficient to cover member ownership decisions versus management decisions. But when you have multiple members and multiple owners, and oftentimes some of those owners are going to be more involved in the business than others, you really need to spend some time and energy inside your operating agreement outlining what rights, what responsibilities, what powers your managers have. Who are those managers, so that you can identify them. This is also important in a multiple ownership structure, because you can limit an owner from being able to make managerial decisions like opening a bank account or signing a contract, things like that you may not want somebody who's not actively engaged in the business to do, but as a member, they could be perceived as having that power. So little bit of nuance to how you divide that up, but I think the big picture there is when you're talking about membership rights versus management rights and powers, That's a big piece of your operating agreement for an LLC. In your corporate bylaws, it's a little bit less so. Your board of directors is going to have some inherent power and authority to make decisions. You can limit that to a degree in your bylaws, but your executive officers and management in the corporate setting are going to be largely in charge of the decision making there. And then the other big piece beyond the buy sell, which we kind of talked about already, is your ownership interests and how those are identified and what bundle of rights comes with those ownership interests. And so in a corporate side, it's very straightforward. Again, it's a creature of the statute. So your ownership interests are shares. All of your shares, generally speaking, are, and you can have different classes of shares that involve different rights. That becomes, I'm going to say overly complex, but that does create a more complex structure for your governing documents. But it is possible to have a different sets of shares so that different types of owners, receive priority dividends. There are other reasons to set up different classes of shares. In an LLC, it's less rigid, it's more flexible, as I've mentioned several times, and so you can really set it up contractually to suit your particular circumstances. One common scenario that I see is you have someone who's actively engaged in the business, putting a lot of sweat equity into running the business. They're the hands-on, day-to-day person, and maybe a partner who is bringing the cash flow to help with the startup costs, to help build out the team, to whatever the case may be, but more of a passive investor. And so it in an LLC, and this is one of the ways it can be favorable from in relation to corporation. Like corporation, like I said, shares are all priced the same. In the LLC, by default, distributions are made according to your membership contribution. So if you have a passive investor contribute 70% of the capital to start the business, and your more active manager is contributing 30%, that's how you would typically, as a default, divide up the distribution of profit and loss. However, you can get creative within the contract, and the operating agreement is a contract between the owners to say that, okay, we're going to actually distribute profits a little bit differently. Even though there's a 70-30 capital contribution differentiation, we're going to distribute profits and losses 50-50. It's because of the sweat equity, the active management that's going on by the one partner. And again, this is where multiple member LLC operating agreements, they don't have to be, but depending on how complex and varied your structure and your actual operations are, I've seen 75, 80 page operating agreements. And again, that's not to scare you off, but that I want to impress upon you the importance of having someone who understands these things. And in this case, it is a legal advisor. I know there are some CPAs who, recklessly, in my personal opinion, will dabble in advising clients on their operating agreements because of the financial components. This is really a team effort, unless it's a tax attorney or attorney who is extremely confident in their understanding of the tax law and the financial implications of these distributions. It's very hard to advise multiple owners on the legal side of an operating agreement and the tax side. So get with your CPA, get with your primary legal counsel or tax attorney, and figure out how you want to divide up those ownership interests and how you want to handle that within your operating agreement. That's going to be probably the biggest, I don't want to say debate or discussion, but that is going to be the meatiest part of your operating agreement, is how do we handle our profit and loss allocations. Second, and a very close second, will be how do we handle bringing on new partners or allowing existing partners to exit the business one way or another. That's where operating agreements can and do get complex, but they need to be addressed, because if you don't, you run the risk, and I've seen this and sadly happen, where you could be a partner in a business and you could be trapped because there's no market for you to go out to sell your interest. You're not allowed to go sell your interest without your partner's approval. And so then you're stuck in a business you don't want to be in. Your capital's tied up there. You may hate your partner for whatever reason. Things change over time. So again, very important to think through the down the road type questions up front and get those documented in your operating agreement. These are not forever documents. They can be changed. The very nice thing about the operating agreement, it's the contract. So as long as the parties agree to change the terms of the operating agreement, it can be changed at any point in time as your business evolves. But really, the more you can iron out up front, the less you change it, the better. I'll pause there because we're kind of transitioning to another topic here. So if anybody has any questions about entity
see-
selection, organizing documents, governing documents, now would be a great time to jump in on there.
I don't see any yet, but at that last couple of minutes, you said profit loss allocations and new partners. Sounds like a bad marriage, you know. So, yeah, it's kind of relatable, huh?
Yeah, it very much can be, and that's where I try to be sensitive to everyone's circumstances, so I hesitate to use that analogy. But business divorces can get as ugly or uglier than personal divorces, and so that's, again, it's less I'll say taboo maybe to talk about that business prenuptial agreement, which is essentially your operating agreement, than it is when you're getting married. So I can't encourage you guys enough to put the time in ahead of time and think through that. Especially if you're bringing on partners, if you're just setting up your own single member LLC or sole owner of a corporation, put the documents in place, but you can work on amending those before you bring on the partner. Make sure you do it before you bring partners on, not after, because then it's harder. But generally, when I talk about the complexities there, it's the multiple ownership thing, and that's too. I'll add, for the setting expectations, I mentioned costs and understanding the costs involved in setting things up. Costs can vary widely depending on the complexity of the business you're forming. So a single member LLC is not typically, even with legal assistance and financial advice and assistance, isn't going to be nearly as costly for you upfront to set up as a multiple ownership structure will, because inevitably it takes more time to work with all the owners. All the owners involved have different competing interests. Sometimes they all bring their own legal representation to the table, and so the attorney you guys or somebody may have identified as the one to represent the business isn't necessarily representing each of the owners. And there are circumstances when that person shouldn't be representing the interests of the owners because they're so divergent. Those are, again, relatively rare. Usually everyone gets along, everyone's coming at it from a relatively equal playing field, to where one attorney can help, but very, very much can impact the overall cost and time involved in getting it set up. And if you're thinking about opening a shop and you haven't, or you're thinking about bringing on partners, these are things, and this is why I set this first session up like this. So these are some heavy things to think through before you even, get to what this slide on the screen is pointing to, which is licensing, which is kind of the trigger point to start your business officially. So that's what I would emphasize there.
Okay, we do have one question here. I recently relocated my business to a relatively modest metropolitan area. I was surprised how many individual mortgage brokers there are competing for the same business. Have you seen any mergers of brokers to quickly gain scale and cost efficiencies?
Yep, absolutely. I think that is something that, especially in the market we're in now, and we're foreseeably going to be in for a little while, consolidation across the board. And when people hear the word consolidation and mergers and acquisitions, everyone jumps to the big boys and thinks about, big companies buying up other companies, or big companies buying up small companies and turning them into branches or whatever. But small business to small business mergers, partnerships happen, and they can work to everyone's advantage if well thought out and done properly. The biggest, I would say, things that I can encourage you to think through before doing that is, obviously personality matters, making sure that you're able to work with this person, because you're definitely talking about being business partners. The best business partners usually bring different skill sets to the table. In the case of mortgage broker companies, you might specialize in govy loans. And so you might want to find a partner who does more conventional. You might want to find a partner who's really, really into reverse. And that's a quick, relatively quick and easy way to diversify and expand your company's offerings. And now, sure, you're also dividing up the pie, 2 ways, 3 ways, 5 ways, whatever the case may be. But if you have relationships with your competition, your competitors in the local area, good relationships, and you're able to have those conversations and say, what would this look like? This is the type of conversation I would encourage you to have. What we're talking about today is, how can we form a partnership that makes sense for both of us? What will this look like? How not everyone loves running their business. Some people start businesses for different reasons. And so these type of small business to small business mergers sometimes can be huge wins for everybody involved.
Right. Okay, and I think that brings to the next question. What is a good way to decide the best percentage to give a partner? Is there a difference in 25% versus 20% besides money? Does making decisions get harder at that percentage split? Question their tax liability question.
So, fantastic question. Decision making does get harder the more voices you have in the room. And so if you're bringing on one partner and you have 80% and you're giving up 20 or 25%, you as the 80%, 75% majority owner control everything. Unless you give that minority partner a say in certain things, you can largely control the business entirely yourself. Now, as soon as you bring on a partner, even a 5% interest, you have a certain level of responsibility to that partner and to their financial investment in the company to not waste it, and waste in a legal sense. Like you have a limited fiduciary responsibility because that person is an owner in the business to not do things that would be harmful to that person's ownership interest, to do things that would be harmful to the business. Again, most people are like, why would I harm my own business? It has happened, and it does happen, where a majority owner, for whatever reason, personal or otherwise, takes adverse action against his or her minority owners. And so it's important to be aware that you can't directly seek to cause them harm or financial loss, but you can pretty much make decisions yourself as long as you're the majority owner. If you have more than 2 owners, that's when decision making can become more complicated. You want to think through how much those percentages are that you're giving up, because anytime a group of owners other than you can together form a majority, you've lost control of your company. Just for ease of conversation, I'm going to say it's your company, because we'll talk about bringing on partners. So yeah, you want to be thoughtful about that. The considerations in terms of how much you give them, it's largely due to their capital contribution, and depending on, so 2 things. It's largely due to the capital contribution, and you want to make sure that you have an accurate valuation of your company before you bring a partner on, so that it's fair and reasonable, because that's going to become a benchmark for future partners. It's going to become a benchmark for how and if you allow a buyout. So you want to make sure you value that properly. Too often I see business owners, single member LLC owners, say, I'm going to bring on a partner. I'm going to throw, this person's worked for me for 5 years. I want to throw this person 5%, or I want to throw this person, 10%. Okay, well, how much are they going to pay to buy into that? Well, I just want to give it to them. They've been a great employee. That can be a problem. That can be a challenge. There can be tax consequences for the employee at that point in terms of receiving something of value, whether it's shares or membership interest. These are all things that you want to make sure you iron out and think through with your legal and tax advisors ahead of time. But it's not something to stress too much about bringing on partners, but it's these little details that you do want to think about, and valuing it is a big one that does get overlooked. It's owners get lost in their business and they feel that, well, I don't know how much 5% of my business is worth. We made this much last year. It's worth getting an independent valuation. A lot of CPAs will do an informal one for you. or it can at least point you in the direction of different metrics to use to value the business based on cash flow, accounts receivable, contracts, things like that. So there are metrics out there, if you get the right people involved to advise you on it, that will help you put the right price, the right percentage on what you're trying to do. And it also boils down to, what are you trying to accomplish? Do you need a cash infusion? Is that why you're bringing a partner on? That can make a difference as well. The level of engagement in the management of the business is another factor. So if you started the business, but you realize you hate running the business and you really like making loans, and that's what you want to focus your attention on, and it's killing your production to manage the business, you may be bringing a partner on to do more of the business work, and that may warrant a higher percentage of the profit, even though they're not directly producing the business. So again, very fluid. Just like the other question, tell me if that did not adequately address what you're looking for with that question. But it's a fantastic question, and I hope everyone kind of files that one away for thought processes when they're talking about bringing on partners.
Yeah, that was a great question. Thank you. So it looks like we're into licensing now.
Yes, licensing. So we've talked about all the prep and all the legwork, and what do we do in terms of putting the foundation on the business, on the house, even putting the framework up, getting the structure in place with your operating agreements, your governing documents. Licensing is another huge part of opening up a business in our world. And this one it's important to spend some time on, not because of its complexity, but because of where you want to think about it fitting in your timeline of launching your business. We talked about having realistic expectations in terms of putting all the pieces of the puzzle together. This one really ought to be one of the very last pieces that you look to accomplish. And the reason for that is, with our mortgage industry licensing construct, you're not going to be issued, your company will not be issued a broker license without you being tied to it as a principal loan originator. Once you tie yourself to your company as a principal loan originator, your current employer, if you're currently employed, will get notification of that. Even the best employer-employee relationships can be rocked by that type of information, whether it comes from the NMLS out of the blue, or whether you have a conversation with your employer and say, hey, I'm going to do this. I'm not going to say that most of the time, because I don't know that is the case, but a fair enough percentage of the time, you're going to be out of a job as soon as your licensing application is processed. As soon as your license, your individual LO license, is attached to your new company, you're probably going to be out of a job. You are most likely not going to be given the courtesy of continuing to close loans for your current employer. I don't by any stretch say that is universal. I've seen it happen where transitions have been smooth. Employers have been like, great, I'm proud of you. I'm so glad you're going out on your own. Close out your pipeline. Let me know what your end date is. This will be smooth and easy. It usually doesn't happen that way. It usually is a thanks, appreciate what you've done. All of your access is now turned off, and I don't want to see you walking out of here with any files. And so you need to be prepared for that. And that's why I leave licensing kind of to be discussed after we get through all those organizing pieces. You also need to have those in place to move forward with licensing. But once you go into licensing, you're in it. So you want to be ready for that. I have a note on here, you can DIY this, or you can engage a third-party service provider to help. There are companies out there that assist with licensing your company and with your LOs. I have clients who use the third parties. I have clients who do it on their own. There's no right or wrong way. It's your comfort level. Obviously, there's a cost involved to engaging a third party. Arguably, there's an efficiency to that, but my experience has been that the licensing process is not overly complex. NMLS, for however you feel about them in general and whatever faults they may have, my experience has been that their customer service is pretty good. And my experience with most regulators has been that the customer service with licensees and prospective licensees is pretty good. Most regulators are interested in helping you do it right, helping you get the right documentation in place. If you don't get it right, most regulators are not going to just be like, rejected, come back again later. Most of them will reach out and say, hey, this is deficient, you're missing this isn't actually what this form means. I've seen instances where regulators have said, hey, do you want me to reject your application because but it's not going to get approved because of your criminal background check has not cleared. Would you like to withdraw it? So regulators are generally speaking reasonable. The OFR in Florida is very reasonable, very, I think, responsive to their licensees and prospective licensees. And so, I think that doing it yourself is very achievable, and very, very much possible. You do need to have your individual MO license so that you can attach it to your company license. If you are, for whatever reason, not licensed and looking to start your own company, that can be a problem in Florida, as there's a minimum 1 year experience requirement as a licensee before you can be identified as the principal loan officer for your company. And every company needs a principal loan officer. So if it's just you trying to go out on your own, and let's say you just took your test, just got licensed, that's going to be a hurdle that you're not going to be able to overcome without seasoning for a year. But that's something to be aware of in terms of your planning. Again, most of the people I encounter are coming out of employment with another entity, and they already have their license. So it's just about getting your broker license, and then attaching it to the company. Branch licensing is something else to consider. Again, if it's just you starting out, probably not an issue. You're going to do your business. You're going to conduct your business out of your principal office location. But if you have a group of partners that are coming together, a group of co-owners who may be spread across the state so that you can reach different geographic areas, each of those branch locations that you operate out of, if you're operating out of branch locations, needs to be licensed. We already touched on timing, the importance of making sure you think through what this is going to do to your relationship with your current employer. And then I emphasize complete documentation. Again, the regulator and the NMLS are really pretty helpful to work with, and will help you get through this. But the licensing process overall is so much faster and more efficient if you're able to submit a nice, clean application package, and the regulator can see it and approve it. And then if anybody jumped on late, I'll just reiterate what I said at the beginning in terms of timing. Applying for a new company license during renewal season in November and December is going to delay your process. I'm not saying don't do it if that's the best time for you, pipeline wise, life wise, otherwise, but be prepared for that to drag on longer than maybe if you were applying in May or June. So just something else to consider with regard to licensing. So as we start to wind down here, we got about, I think, 15 minutes or so left. Preparing for your transition, get your ducks in a row. I mean, that's kind of the bow I can put on all of this is, think through all of these complicated or even easy things ahead of time. Make sure your thoughts are organized. Make sure your documents are organized. Put a checklist together. Have the conversations with your business partners, but get your ducks in a row, and your transition will be smoother. The timing for your transition will be more efficient, and I think you'll ultimately be up and running and operating your business a lot faster and a lot more effectively. Also, in terms of preparing for your transition, you've heard me say this many times, and my clients probably sick of hearing me say this, but it's about a team approach. I'm a big team guy. I think that having the right team in place sets you up for success. I said it also before. I like to let the experts do what they do best. I am not a CPA, and I will not do. I cannot give as good of advice on the financial matters as a CPA can. Most CPAs are not attorneys, and if they are, they're not often practicing on a full-time basis with business owners, and particularly mortgage companies. And so your attorney is a huge piece of the puzzle and a huge advisor and someone to have on your team and in your corner so that you can bounce thoughts, ideas, concerns off of, and your attorney can pull from his or her years of experience to say, I've seen this happen a million times. This actually isn't something you need to worry about as much as you may think, or hey, you're completely overlooking this, and trust me, this is going to be the thing you fight over when the business divorce happens. Insurance agents and advisors always get overlooked. Getting the right insurance agent advisor, somebody who can help you understand what is best and right for your business. Everybody walks into business ownership going, all right, I need errors and omissions insurance. Okay, that makes sense. but not always. Not everyone's not thinking about what else they need. Cybersecurity protection, additional liability when you're using your vehicle for business purposes to travel to closings or to meet with clients or referral partners. Business property insurance, whether it's an ad, if you're working out of your home, that's usually a rider you need on your home policy if you have business specific equipment that you want insured in your home. I've seen that get excluded from claims before because it wasn't part of the homeowner's policy explicitly. So being able to talk through an advisor on these areas that you trust and they can give you good advice to say, have you thought about this? And I say an advisor because I mean, I'm guilty of this too. I'm very, I scrutinize these relationships for my own purposes too, because sometimes it feels like they're just trying to sell me an insurance policy that I don't need. Whereas others will sit down and tell you, you know what, you don't need that, but you might want to consider this. Those are the types of people you want to work with. And I think that will, again, help put your mind at ease as a business owner. If you've got other people worrying about some of these, discrete areas, other people who have your back, whether it's the financial side and tax side with your accountant, whether it's the legal liability side with your attorney, whether it's, making sure you have the right insurance, then you can focus on running your business, making loans, doing the things that motivated you to get in business in the first place. Again, harkening back to the beginning, manage your expectations for as far as timeline, and identify what your metrics for success are. Sometimes I see people with unreasonable and unrealistic expectations for success right away, and that's okay. You want to be aggressive, you want to be optimistic, you want to say I'm going to go, dominate the world, but it takes time. Even like I said earlier, for someone with a very established pipeline, strong referral sources, your company is brand new. They may know you, but they don't know ABC Mortgage. And so you've got to acquaint them with the new company, make sure that people have confidence in that company, build that brand out. It will come faster for some than others, but it's not something to be taken for granted. I think you want to set measurable metrics for success so that you're prepared and that you can, again, when you're planning, budget and say, okay, it might take me 3 months or 6 months or 9 months or 12 months to get back to my income level at my previous employer. But to just be aware of that up front will help with, again, organizing your transition and making it as smooth as possible. And then again, I'm going to re-review your obligations to your current or your former employer. You got to monitor your pipeline, your contacts, your referral sources, and the provisions of your employment contract relative to non-compete, non-solicit, and confidentiality. These are huge things that can't be overlooked in your transition. If you want to be successful, any one of those things that gets overlooked can derail you. Even if you're operational, even if your license is good to go, if you find yourself served papers to show up in court and answer, either for violating a non-compete or a non-solicit, or worse, if your former employer is very vindictive and tries or succeeds in getting an injunction against you, they can stop you from doing business, or stop you from doing business with some of the clients that you started to work with. And that can be, again, embarrassing. It can be difficult to restart from that, and it can affect your, ability to build out a successful brand for your new company. So just important things that we don't want to overlook. I always close this kind of part of the conversation with hopefully a word of encouragement. You absolutely can do it if you're thinking about it. If you've done it already, kudos to you. I am super impressed with anyone who's got the courage and the fortitude to go ahead and go out on that limb and start their own business. Small businesses, I'm not to get to wax poetically or anything, but I'm a believer in small businesses being the backbone of communities. I think especially doing what you all do and helping people, get into homes, finance their homes, that strengthens communities, builds community. I know from the brokers that I work with, the loan officers that I've worked with over the years, you all take pride in that. And to be able to do it on your own and to become a business owner within your communities is huge. And so I applaud you and I give you credit for even thinking about it. I hope that some of my words, some of the information I'm sharing with you today, and ideally, if I don't chase you off, if you come back for the next 2 parts, some of the information we go over those 2 sessions as well will help you feel a little bit more confident and a little bit more emboldened to take that leap, because the rewards of small business ownership are great. And I don't mean small business in the sense of staying small. I encourage you to grow and set your sights as high as you want them to go. But the rewards are there to be a business owner, and you've taken a huge first step in giving up your valuable time to listen to me today. So I want to thank you for that. And if you have any questions, we've got time to discuss. Yep, we got time.
We do. So if anyone has any questions, shout it out or type it in the chat box. I will tell you, Ryan, this is very impressive. Great material, easy to digest too. So appreciate that very much. We did record it, everyone, and we will be sending out the recording to you. And we ask that maybe you provide some feedback on how, how this went today, and if you received good information. We do have a comment in the chat box now that thank you so much for today. Looking forward to the second series. And so we do have the date, and this is what Ryan will be going over. So, which is definitely part 2. So
Yep, like I said, we tried to divide this up into manageable chunks. And so hopefully today
Right.
was like I said, really about if you're thinking about getting started or just want to review, that whole, am I ready to do this process? Part 2, these are going to be the nuts and bolts where we get into some of the nitty gritty on what you really need to have in place, post governing documents and everything like that to operate a successful business. And then, ultimately in part 3, if I don't lose you all by then, my goal there is to cover, what can you reasonably expect in your first year in business? What are some of the hurdles you're likely to face? What are some of the challenges? What are some of the things that you may not be aware of? How do you prepare for that first exam? Those types of things.
right, some of those scary things that possibly could happen. So we already have people registering and great information as far as in the chat box. So we will, if there aren't any other questions, we will go ahead and in today. And again, we thank all of you for being on this webinar, and thank Ryan Reister for giving up his valuable time. There's his information there, and we look forward to the second one, and we'll be in touch. And thank you for being an FAMP member. That is important to support our association, your industry. And these are the type of information that we try to provide to our members. So, all right. Well, thank you, Ryan. You have a great rest of the day. Courtney, thank you. And all, thank you for attending. Bye.